This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hello everyone, I'm Leonard French, your favorite copyright attorney, and today I want to talk about Devin Nunes' completely predictable loss of his LOL suit against Twitter, his fake mom, and a fake cow. There's a lot to unpack, so let's start with some background. Back in March of 2019, Devin Nunes sued Twitter and several Twitter accounts, including the parody accounts Devin Nunes Mom and Devin Nunes Cow. The cow account in particular is known for tweeting cow pun-filled statements criticizing Nunes. For example, Devin's boots are full of manure, he's utterly worthless, and it's past your time to move him to prison. Nunes asked for $250 million in damages for defamation because the Twitter accounts made fun of him and referred to negative media coverage. He also asked Twitter to give him the real names behind the accounts so he can name them and pursue them in the lawsuit, but Twitter hasn't been cooperating. Now, I know what you're thinking. Isn't criticizing a political figure one of the most protected forms of free speech in the United States? Isn't the standard to prove defamation against a politician really, really high? Well, I will let you in on a little secret. Sometimes the purpose of the lawsuit isn't to win, but about punishing your critics and making them spend time and money defending themselves. These kinds of predatory anti-lawsuits are common, so common that they have a name, a SLAPP suit, a strategic lawsuit against public participation, and many states have so-called anti-SLAPP laws that help innocent defendants get rid of them quickly. While this case wasn't dismissed on SLAPP grounds, the circumstances are similar. Protecting Devin Nunes' free speech wasn't what yesterday's loss was all about. Instead, the judge ruled that Twitter was immune from Nunes' claims because of Section 230 of the Communications Decency Act, or CDA 230, which we recently covered. In short, Section 230 states that online platforms like Twitter can't be held civilly liable for the content that third parties provide. Put another way, Twitter isn't the speaker or publisher of all tweets on their platform. It's the original author that's liable. Nunes tried to argue that Twitter became the publisher or speaker because it has moderation and content policies that give it editorial powers. Let's see what the judge has to say about that. So here is our slightly blurry copy of the Commonwealth of Virginia, a state circuit court, a county court of Henrico County, Virginia. This is where Devin Nunes sued Twitter, Elizabeth L. Mayer, Mayer Strategies, Devin Nunes Mom account, and the Devin Nunes Cow account. And this is the judge's opinion. Now, I don't know how to interpret this. This looks like a letter opinion. In other words, the judge issued their opinion in the format of a letter to the parties, as opposed to the formal opinion format that you normally see on a court docket. So I don't know if that means that the court is just doesn't care, or maybe this is normal for Henrico County. I'm not going to judge it, but just want to point out this is in the format of a letter motion or a letter opinion, as opposed to a full formal decision. I'm not sure what significance that has. And so the judge writes as a letter, "Dear Mr. Biss, Mr. Courtroom, and Mr. Seyfarth," who I'm assuming are the various counselors for the parties in the cases. "This matter came before the court on the motion to dismiss by defendant Twitter on June 12, 2020. The court makes the following ruling based on the filings by the parties and the arguments presented at the hearing. The motion to dismiss by Twitter argues that Section 230 of Title 47 of the U.S. Code grants Twitter immunity from suit for the claims filed by the plaintiff in this case. Twitter relies specifically on subsection C of Section 230 as the basis for the immunity. The court will address the plaintiff's claims and arguments that the motion to dismiss should not be granted. Plaintiff contends," so plaintiff is Devin Nunes, "plaintiff contends that the motion to dismiss is a second motion to dismiss and should not be allowed. The court finds this argument without merit as the first motion to dismiss concerned venue and jurisdiction to hear the case, and this motion to dismiss concerns immunity. Plaintiff further argues that the immunity Twitter claims pursuant to 47 U.S.C. Section 230 is an affirmative defense, and therefore must be asserted as an affirmative defense in the answer to the lawsuit, and therefore not a motion to dismiss. The court finds no authority that states defendant is barred from filing a motion to dismiss claiming immunity from suit before filing an answer. The Supreme Court of Virginia ruled in the Clark versus Virginia Department of State Police case in 2016 that immunity from suit under federal or state law are an appropriate basis for Virginia courts to dismiss a suit at this stage of the case. The court finds the motion to dismiss based on immunity to be properly before the court. The plaintiff further alleges that Twitter is an information content provider, and therefore immunity under 47 U.S.C. 230 doesn't apply. The plaintiff alleges that Twitter's decisions regarding content that is allowed or not allowed to be posted on its internet platform makes Twitter an information content provider, or somehow the creator of the content. Plaintiff further alleges that the content allowed by Twitter to be on the platform is defamatory, and that Twitter is liable for the defamatory content, and negligent for allowing the defamatory content to remain on the internet platform. Twitter rightfully agrees that the court must accept all these facts as true. However, that's the motion to dismiss standard. However, the court is not bound to accept conclusory allegations made without any factual support. The plaintiff concedes that there is no evidence that Twitter or anyone associated with Twitter was present with the author of the content that is the subject of this lawsuit when it was placed on the Twitter internet platform, and that there is no evidence that Twitter or anyone associated with Twitter helped draft the content that is the subject of this lawsuit. Twitter argues that solely by alleging that Twitter is an internet content provider is a conclusion without facts, and the court agrees. The court must look to Section 230 and the case law interpreting the Act and analyze plaintiff's allegations to determine if Twitter has immunity under the Act. Plaintiff would have Twitter be liable for defamation for the content placed on its internet platform by others, and would have Twitter found to be negligent for not removing the content placed on its internet platform by others. Section 230 reads in subsection C1, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Plaintiff seeks to have the court treat Twitter as the publisher or speaker of the content provided by others based on its allowing or not allowing certain content to be on its internet platform. The court refuses to do so and relies on the ruling in Zerin v. America Online, a 1997 case. The court in Zerin stated that Section 230 creates a federal immunity to any cause of action that would make service providers liable for information originating with a third-party user of the service. Specifically, Section 230 precludes courts from entertaining claims that would place a computer service provider in a publisher's role. Thus, lawsuits seeking to hold a service provider liable for its exercise of a publisher's traditional editorial functions, such as deciding whether to publish, withdraw, or postpone, or alter content, are barred. The plaintiff also alleges that Twitter has a bias towards a point of view, and that bias is so extreme that it governs its decisions regarding content that is allowed on its platform, and that course of conduct makes it a content provider. The allegations in the Nemeth Chevrolet versus ConsumerAffairs.com case were similar to those made by plaintiff in this case concerning content decisions being one-sided, and the court in the Nemeth case ruled that the service provider was immune from suit under Section 230. The court finds the issues in this case substantially similar to the issues presented in the Zerin and Nemeth cases, and applies the rulings in those cases to this case, and finds that Twitter is not a content provider based on the allegations by plaintiff in this lawsuit. The court finds that Twitter is immune from the defamation claims of plaintiff based on 47 U.S.C. 230. The court further finds that 47 U.S.C. 230 C2 provides immunity for all civil liability, and therefore Twitter is immune from plaintiff's negligence claim based on the allegations in the complaint and the court's application of the rulings in the Zerin and Nemeth cases to the allegations in this case. I thank you for the preparation of the issues and for all of the information that was provided to the court. Mr. Carome, please prepare the order. Sincerely, John Marshall, Judge of Henrico County, Commonwealth of Virginia. Now that's just Twitter. So this lawsuit that we saw here, this Twitter, the original LOL suit here that asks for $250 million for this alleged defamation, and we'll take a look at these tweets in a second. But this lawsuit here continues as to Elizabeth Mayer Strategies, the Devin Nunes mom, and the Devin Nunes cow accounts. But you can already see that the judge is like, hey, this is a weird defamation lawsuit you got going on here. A parody account on Twitter, I'm not sure how any of that can be defamatory. Remember, defamation against a politician requires actually provably false factual statements that do actual damage and are brought with actual malice. In other words, you really, really want to hurt Devin Nunes, not just criticize a politician that you disagree with. So he has a lot to prove when he goes to court against the accounts and Liz Mayer and Mayer Strategies. There's a lot that you can say that is either not defamatory because it's not actually damaging. In other words, what can these accounts say that could actually cause real monetary measurable damage to Devin Nunes, the politician? I don't think so. You can't. If the criticism causes him to lose votes, that's not what we're talking about with defamation. The second thing is, how could these things be defamatory when they're obviously parodical? They're parody, they're comedy, they're puns, they are rhetorical hyperbole. They are not statements that Devin Nunes has done a specific thing wrong or committed a specific criminal act or something like that. They don't even seem to constitute defamation per se. Let's take a quick look for the lulls. So here's the Devin Nunes mom account. Twitter conspiracy meeting tonight. Don't tell Devin. I'm assuming that's a picture of his mom. And of course, I'm also assuming this is not really his mom. She says, I'm going to sue my son for being too sensitive. And it refers to DevinNunesCow.com. A shameless plug. I'm not associated with these. Anyway, Devin Nunes Cow apparently follows me. So the Devin Nunes Cow account says Devin is a loser and hanging out on the dairy in Iowa looking for the little treasonous cowpoke. So maybe Devin Nunes is upset at being called treasonous, but I'm pretty sure this is obvious rhetorical hyperbole. And here is the plaintiff of our story here. This is one of the tweets, a tweet, "Do you need a safe space, Devin? There's space in the barn." So a very nice tweet inviting him to join the cow in the barn for some safe space time. And then here's the tweet I read earlier. Devin's boots are full of manure. He's utterly worthless. It's past your time to move him to prison. The herd supports Jans for Congress, Valley resident, anti-crime prosecutor, California 22. Needs a representative who works for us full time. So I'm assuming Devin Nunes Cow is maybe living in California, District 22. I don't know. So yeah, you can't sue Twitter under this totally weird, inept, inane, idiotic theory of publisher versus platform. That's not a thing. They have CDA 230 immunity unless Twitter actually becomes the originator of the defamatory content. And even then, was this defamatory? We didn't need to get to that as to Twitter, but as to the other defendants, we probably will get to some kind of motion to dismiss or a motion for summary judgment, and it will probably involve arguments about how rhetorical hyperbole is not defamatory. I don't know if Virginia has an anti-slap law. If they do, we'll see that brought into it, I think, by the defendants who remain. Let me know what you think in the comments below. Lawful Masses is a community-supported YouTube channel presenting legal news and education to you, our lawful masses, and I am Leonard French, your favorite copyright attorney and channel host. Thank you to the following supporters on patreon.com/ljfrench and sponsors.com/law, and YouTube memberships, Floatplane memberships, and Twitch supporters: At the $50 level, thank you to Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian, Hellman, J. Dixon, Ameknight, Oscar the Prophet, and Hot Grills in Your Area. And thank you to the $5 plus supporters who are scrolling on the screen in front of me, on the LED panel beside me, and everybody gets put in the description of the videos that drop. I love you all. I'll see you in the next one.
57 degrees or something?
I know we're acting stupid. Maybe just a little bit foolish. But I feel so young. Just go a little crazy and lose it. I don't care if we're dumb. It's the only way we know how to do it. I feel so young. I know we're acting stupid. Maybe just a little bit foolish. Just go a little crazy and lose it.
Good girl.
Kill the lights.
Oh, not bad. Not bad. Not bad. I like that one. Not bad at all.